Hey, what's up, guys? Welcome to Law Explaining the Interwebs. I'm your host, Nick Ricada of Ricada Law, a small law firm in central Minnesota. How are we doing tonight? Holy crap, it's late. I mean, not really. Based on history, it's not really late, but it's kind of late. Feels late for me today. How's that? How's that? Oh, boy. Well, I don't know, guys. I don't know. I wasn't going to do a show today in general. Like I was, and then I wasn't. I was waffling. I was trying to decide. And then like something happened today. There was a court hearing. I don't know if you guys are aware. But the mic sounds tinny and motherfucker. Hold on. I got it. This should be better. Sorry about that. I hope that fixed it. Is that a better that's got to be better mic, right? Okay, good. Yeah, it had the wrong mic selected. I don't know why. I don't even know what my funny story. I don't know what that microphone is. I don't have a microphone that is attached to. So I don't know what that is. I don't know what that is. But anyway, I'm here. God. Some of my stuff got messed up. I wonder why. So anyway, hey guys, I'm sorry. I got a weird hair. I got a weird energy today. I'm tired and exhausted and like emotionally spent. But a big happening happened today, and it's something I can actually kind of talk about because it's not my case. It's not mine, even though it's like really close to mine. So, I figured I'd come online and talk about it. Some of you have probably seen the main source of what I'm going to talk about, which is April Imholt's first appearance, which had a little bit of a doozy attached to it. It had a motion to dismiss. We don't normally have those on first appearances. They sometimes have a place. They don't always have a place. And you've probably seen people like analyze the motion, or you've seen people watch the hearing. We're going to do maybe both of those, even though we know the outcome of the motion hearing. Let me just say from the get-go, the case was not dismissed at the first appearance. I don't know if this is one of those things where you don't plan to have that happen because you're probably not going to win, but you can hope. Also, some things can come out of it that are semi-useful. And I want to talk about those things today. I don't know what anybody else has said about this thing other than there's a lot of chatter about where April seemed to be when she was on her Zoom call. The background was really blurry, so I don't know where that was, obviously. I hope the court doesn't find out. That would be so bad. It'd just be terrible. Oh my God. Hopefully they never find out where that was, because that would somehow affect something somewhere. But yeah, so here's what I figure. I figure, hey, I can watch this thing. We can read this paper. We can talk about what happened, and I can give you guys maybe some insight that no one else can. I'm not sure if you want that or not, but that's what you're going to get. That's what you're going to get. And yeah. hopefully you'll enjoy it, right? Like, this is an entertainment show. I didn't say it was entertaining. Don't you dare fucking hold me to that. I have a McDonald's Coca-Cola here, and I'm going to run out of it soon. But hopefully you get some entertainment out of it, maybe learn something, and maybe I can give you a little insight into some of the stuff, because there was some interesting bits that happened on that hearing. I was kind of surprised because it's like 10 minutes. It's not a lot to do, not a lot of time. And it's amazing that the state can be the state in such a short fucking time. But hey, that's what they do. Shut up about court cases, Nick? Well, no, I don't want to. What would you like me to talk about? What makes you happy? Nick asked his lawyer before going live, and he said, "Sure, bro, yap it up." He probably would, but I didn't ask him. Do you guys walk around asking for permission to do stuff in your lives? I don't know, man. I see so many people out there these days. Sorry, I'm just cleaning out my ear monitors before I put them in. I see so many people out there these days begging for rules over them, begging for a system to come in and protect them from something. I don't even know if they know what they're being protected from. Like, look, we obviously want a government to come in and keep you from getting mugged or murdered or robbed, or they don't actually do that typically. They're not really good at the preventing of those things. They have one preventative function that's relatively useful, and that is the threat of punishment. But the threat of punishment is not an active means of protection for people. It's passive, right? It's the idea that someone won't do something that they otherwise would because the consequences will end up being bad. The risk is too high. But then there is an active protection that can take place, right? A police officer can be somewhere and stop someone from doing something. And if you have that, that can be useful, but it's really fucking rare that comes across for most people. I mean, most people are not going to be in a situation where there's an active intervention by a police officer. Ricardo Law has no idea where April was zooming from, and no respect for his audience. She was right here in my office, you weirdo. What do people think it's like a mystery or like a secret? What kind of, I honestly, I don't even understand the internet. I think you guys can find it if you look. People have gone so autistic that they don't even remember that, like, I don't think they even remember what they're, I don't even know how to describe this. It's not mad at, it's not marveling over, it's not watching. They just forget what they're even in, so that everything becomes interesting even when stuff isn't. It's so weird. It's marvelous to watch. And I have another thing that I was going to talk about today. And the Kiwis will be very happy to know that I had to read up on my thread a little bit, and I found something that was great, because it's Kiwi farms acting just like government. And I get to demonstrate that in this case, and why it's so why it's such a weird problem that comes up. And the one thing that's consistent in this life is if you point out something to someone, they get really angry about it. That goes for me too, right? Like I'm not even being critical here, but I tried to point this out to a former friend a while back, this symptom that the Kiwis have. And the farms has this problem. They don't realize that they do this all the time, but when they find themselves doing it, they then like explain it away after some mild argument, and then it just kind of disappears. But it's this phenomena of like insular telephone. And it's where something happens, and then like a fact is created or completely wrong, and then just gets adopted as the truth, and people run with it as the truth as if it were, and it becomes the truth. Kiwi Farms acts like they're very thorough and investigative and all this stuff, which is fine. Sometimes they are, sometimes they're not. But what they always are is adding or omitting critical details that change or create out of nothing stories that become kind of official canon of internet retards. And the government does this too. And that's what was really interesting to me today, was seeing the government do this, do the exact same thing that Kiwi Farms did. And the only reason I can bring it up is because if you tell like anybody on the forum that they do this, they'll deny it like crazy. They're like, this never happens. And then there's like the one guy's like, guys, it kind of happens, all the time. But like we try and fix it. But if you try and tell them, they'll spurg out about it until you can show them. Then when you show them, they're like, oh, well, this happened. Well, I mean, it's only this time. Okay, sure. But they take this thing and they create a fact that becomes a reality. And that reality then just persists on. That's happened in this case in a way that I can demonstrate through the hearing today. So it's something that I can bring to you guys that I don't think anybody else will be able to. But maybe they can. I don't know. I'm not watching their coverage. Let's get a rumor started on the farms that Nick has space AIDS. No, not space. I don't have space AIDS. Deep sea AIDS, maybe. I don't know. We got a couple super chats to start. Then we'll get in. This is probably not going to be the longest show tonight. The main topic is the April hearing. And then we might talk a little bit of Supreme Court stuff, but that's kind of just in case we get to it. I think most of it's going to be here. I said I wasn't really planning on doing a show tonight, and then it was like, oh shit, I'm not going to go like 3 hours. I mean, I guess it's always possible that I could, but I'm thinking it's going to be a much shorter show. And yeah, we're just going to go through this April stuff, and you'll see. But guys, don't tell the government she was in my house. They'll go back in time and arrest her. That's been one of the funniest things to watch today. Is everybody's like, whoa, Nick's busted now. It's like, God. Busted with what? Oh my God. It's very funny. I don't know. Maybe it's not funny. Everybody kept saying it was funny, so I have to adopt that, I guess. But nice podcast, stupid. That's a good name. Says sometimes you wear Baldo. Sometimes Baldo wears you. I don't know if it does. Yeah. The act of wearing is to put something over, right? So you would put on a ball. I don't think. Okay, I guess you could wear. Yeah, Baldo could wear you. Like, okay, never mind. Let's not go there. That gets deep. Travis Hill says your studio looks less fuzzy than earlier. Yeah, I had to adjust the focus on the camera. SVH says I always make the mistake of reading the chat. Do you think there are gay bots in your feed repeating the same zingers? I don't know. Look, it's 2024. I don't care if the bots are gay or not. Like, we used to like really be looking out for that, and nowadays it's fine. They can be straight. They can be gay. I don't know. I hope so. Guys, like if YouTube like is gonna send bots to inflate their advertising numbers or something, like, okay, I guess. I don't really make hardly any money off of like the ads, so it doesn't really matter to me, but I'll take them anyway. Koof says thank you for not killing yourselves. The night is young. Just kidding. That was a joke. The night's not that young. Mitch Marco says, hey, Nick, do you know of any, or will there be a clips or review channel comparing the LawTube analysis of your cases versus what really happens? Well, it sounds like you just made it up there, buddy. Can really expose these grifters. Seems like prime real estate. The last thing I'm going to do on earth is watch a bunch of people's coverage of this fucking fiasco. It's maddening to watch. Like, you have to understand a mild perspective difference. Okay. Uh, between me and anybody else watching is that I'm here on the inside, right? Y'all are all Aaron Lewis on the outside looking in, but I can see through you. No, I know the story from this side of it. And so when I watch like cockeyed Limpy over there trying to muddle his way through a fucking document, I just want to pull my teeth out, because not only is he retarded, but he's really, he's really, but they have basic parts of the story wrong. And some of that isn't their fault, right? I'm not blaming everybody on not having it. You guys didn't live it. I did. And so that's why I'm able to point out some of the shit today. I got a lot of grief for saying that Alicia Sweep, the county investigator, lied under oath at my in one of my hearings, the first or the second hearing in my family case. People are like, how dare you? Can't believe he said. Well, she lied under oath. I mean, there's not really much to it other than that, but she did, and it's one of just a ton of these little lies. I talked about this the other day. A conspiracy isn't like some massive organized thing to go after people all the time. Obviously, they have those types of conspiracies, right? But nothing needs to be that complex. It's literally just little places where people do their job poorly. And one of those happened today in the hearing, and I'll point it out straight out to you. And it was actually it was an important one, and it involves a government agent lying to the court, just straight out lie. And it's kind of amazing that they would do that, but they just do. They just go ahead and lie. And people think like, oh man, it's like when they say that the government lies, it's like this big thing, or it's organized, or there's some I don't know, something to it. But no, they're little bits and places where they leverage the system as it functions. And these little lies or untruths or whatever kind of just impact your life in dramatic ways, and there's not fucking much you can do about it. And I think if you get a cop or something that you know and you trust, and you get them a little lubricated, you could probably get them to talk about this and how this happens, because cops are kind of king of doing this. It's these little lies and misrepresentations, just a tiny bit moves the needle enough. It moves the needle enough to do something else. And if they're not doing it, someone they know is, an administrator is. If you work in corporate America, if you work in a government, anywhere that there is someone who has power, and that power depends on a set of variables, and they have any ability to nudge those variables, they invariably get nudged. They get nudged towards the end of the person who's nudging, right? Like, that's kind of human nature. The problem really is when it involves the impact on someone else. This is where we'll call it sin, where all sin culminates. I mean, if you lie about something that doesn't fucking matter, it doesn't fucking matter. But if you lie about something and someone loses $1,000, then it matters $1,000. And that's, to someone that's a lot, to other people, it's not a big deal. It's all relative to who you are, your circumstances. But these little nudges, when it comes from government, and when it involves liberty, and when it involves your rights, that's when it matters a lot. Because I tell you what, those little nudges end up with you in jail and being fucking just excoriated by a public who has no actual clue what happened. So I got to stop waxing poetic through this stuff so we can get into the actual show, but we will. But yeah, will there be a clips or a review channel like comparing and compiling all of it? I mean, people have made shittier businesses, so probably somewhere. I don't know. I don't know that the market lasts for it. See, this is the other tough thing is you can have a really cool idea with a really captive audience. There's a lot of people who are interested in my case, for example. Well, once my case is over, you then have to figure out what to do next. And you can't just rely on me to run around committing felonies, okay? Some of you may disagree with that, but you can't, because that doesn't sound good to me. And so you'd have to find some other source to keep that captive audience engaged, interested, and you're not going to have another case like this pop up, most likely. Or even ignore me, like even if I'm dead or whatever. It's going to be hard to find another comparable situation for a while. Given time, it will happen, but when it happens is, anybody's kind of guess. But yeah, I mean, if someone wants to make that channel, I'm sure someone will, and I'm sure they'll get something out of it, and it'll be great. Nicola Maxwell says, Nick, you look well. Hey, thanks. Please help Broken Baker get to 12K trial fun. Broken Baker, great channel and humor. Guys, check out The Broken Baker on YouTube. See if you like their channel. Subscribe to it, maybe. I don't know. Carazola X, Sandra Birchmore case is absolutely wild. Have you seen anything about it today? No. No. Guys, pure confession. So when I do stream, you've noticed, maybe you haven't noticed, probably not. I've not been streaming a lot. When I do stream, it's anomaly that I'm actually like looking into the stuff I'm going to be talking about on the show. Most of my day, I'm not like perusing the news or anything. It's difficult for me because all I want to do is talk about my case. Like that's what I'm thinking about. That's what I'm reading, documents and documents and documents. All of this is what my brain is doing all day because it kind of is important for me. So it's hard for me to think about other cases or to think about other subjects. So I'm not following along other stuff. I have no idea who Sandra Birchmore even is. Involves the same officers as Karen Reed. Oh, those guys were gems. I'm sure that's good. Don't worry, they're all good. Justin DGBZ says, what are your thoughts on posadism? Posadism? Oh, this sounds horrible. I'm going to regret this, aren't I? Advocate for a society akin to those proposed by general Marxist theory. Oh, so they're Marxists? No. That's my thoughts on posadism. No. No, thank you. Darn Bungholios says, stop being a fagel. Okay. Happy Hippie. Whoa, with a huge super chat. Thank you so much. Says, usually catch you on the replay crew, but happened to be up late tonight sending many prayers. Man, thanks for all you do. Stay gay, my friend. I will. Hugo Itano says, glad your kids are back. Thanks. It's been really good. I don't know if you guys remember, that was August 7th. August 7th, I think. Yes. Yeah, it was going to be the 11th. It was going to be the 11th. It ended up being the 7th. That was a nice surprise. So this is one of those things where I can't really watch other people's coverage because I'm watching from the inside, right? I knew that my kids would be coming home on August 11th, back in July. It ended up being August 7th because just worked out to be a couple days earlier, which is great. But I knew that back in July. And all throughout July, all of these outside analysts are telling people that, like, I'm not going to get my kids back for a really long time. There's all these allegations going on about abuse and neglect, none of which actually manifests anywhere, ever. But they're sitting there saying this, and I'm like, guys, I know exactly when my kids are coming. I know I know the date they're coming. And then people are telling me, like, they're posting these transcripts that were from a month prior, and they're like, oh, look at this is working out. They're like thinking it's going to be a bad result. And it's like, no, that already happened. We're well past that. So it's hard for me to watch it because I colloquially say I can't talk about my case. Obviously, I talk about my case with relative frequency, but there are details and aspects of the case that I can't talk about. It's pretty wild, and it's a pretty amazing story. But hey, what's up, Nightwave Radio? How's it going, Mersh? Been a while, man. He rated the stream over on Rumble. Welcome to the Nightwave Radio viewers. You know, where the hell was I? Mersh, you just distracted me. It doesn't matter where I was. I see the thing is, I'm watching from the inside. I know these details. I can talk about various parts of the case that are like set in stone, but I don't get into talking about legal theory and you know, like evidence and all that shit. And that's what I want to talk about, but that's the stuff I really have to stay away from because we've got a fight going on here. But it makes it difficult because that's what I want to do is talk about that stuff, and I can't. And then I see people, and if I listen to what they're saying, I'm like, well, this is just wrong. You don't even have any idea. And they're chuckling the whole time too, which is fun. I'm glad they're having fun, but they just have basic stuff wrong, and they just don't have access to the info. Citizen M says, I've been interviewing Local and AM, doing a video essay on the life of your wife, Kayla. Any chance you'd be willing to speak to me? I'm a nobody ST mod. No, there's no chance I'd be willing to speak to you. You know, you could pick a fun bracketed euphemism that involves something terrible you could do to yourself. Jack Johnson says, why have you failed to abide by a judge's order and pay Monograph $300? I haven't failed to abide by it. I just haven't done it yet. You were ordered to do so over a month ago. Well, don't order me to do stuff. I don't like to. Lord of the Kino says, what was it like being the corner demon for April? It was good. It was good. I you know, I had one of those towels and like a bucket, you know, kind of like doing that thing in case it got too warm. Speaking of, it's fucking hot in here. Guys, the secret's out of the bag. Someone used my office for a Zoom call today. Broken Baker says, good thing about people being on the grift, they show the true color for the quick money. In the Birchmore case is a cop grooming and graping a 15-year-old. Oh my God. Ew. Well, if they're guilty, may they burn in hell. That's fucking horrible. All right, there's a couple of Rumble rants, and then we'll get into this thing. What should we do? I guess we should read the motion first, and then we'll watch the stream. I think that's the best way to do it. Nightwave Radio says, DM me on Twitter at the Bad Luck Boys. We talked about getting back in touch before the unpleasantness. We did. I blame you actually for that. Yeah, man, I'll hit you up for sure. Okay, let me get this case pulled up. Access case records. Dun, 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 dun. Oh man, I tell you guys, this whole process, being charged with felonies, I don't recommend it. It's not. There are other more productive uses of your time. Why the fuck is this not working? Oh my God. Of course. Hold on. I think I have to. You know, like when a system goes down, like right when you need it, not system of a down. I was going to pull up this document so we could actually fucking look at it. Here we go. It's probable cause statement for April. But okay. Don't want to put it there. That's what he said. Hold on. I just have to yes. Save. Good Lord. I have to get it from a different source. I had to move it from my phone. You know what's great about drug testing, guys, is that you really get to be friends with the person who's looking at your penis all the time. Like you're in there. You're just in there. And you're like, oh, how are you today, Nick? And I'm like, I'm fucking terrible. How are you? I'm like, oh, pretty good. The weather's nice. I'm like, yeah. It's like, want to get back out on the lake one more time this year. I'm like, that's cool. Unzip, pull my dick out, and then start peeing into a cup in front of this person who's staring at me. I'm like, this arrangement doesn't bother me as much as it should, but it really should bother me. Something's uncomfortable and comfortable about it at the same time. Sorry, I've got to get this. Are you essentially saying that you should only commit misdemeanors? Yes. Very well weird. Oh my goodness. Oh, okay, I've got the document pulled up here. Again, sorry about this sort of disorganized thing. That's what you're getting tonight. I'm not gonna actually. I'm unapologizing for that. I'm unapologizing for the disorganized aspect of today because it's too silly. Okay, so here we go. Lucky there's supplements to flush that coke out of your system within 5 hours. Homie, if you are trusting a supplement to like keep you clean from whatever the government says you can't do, I don't know what to tell you. I have no idea. You must never have been tested before and have it fucking matter. Because when there's anything important on the line, if you're trusting some supplement to flush your system out, those things can't even make you fat asses skinny. Okay, here we go. Count one. So here's the complaint against April Imholt. Yes, it is April Imholt. No, this is not the correct address, actually. This is weird. I'm not sure why this address is here, but April has a different P.O. box. I think there was someone out there who maybe lied and said that something was sent to a P.O. box that belonged to me when it actually wasn't. It was sent to a P.O. box that belonged to April. But someone out there suggested that it was mine. And then that lie permeated into some fact, I guess. But that was never true. The person who said it knew they were lying too, which is interesting. But that's the way these things go. So this one, though, this is my P.O. box. I'm not sure why it's on here. So just as a hypothetical, there's a couple of things about this complaint that should stand out right on their face, right? April is not April Imholt anymore, and the address is wrong. So there's a question about if she's properly served in this case. And before you jump down my throat, okay, which sounds like a fun time, before you jump down my throat, hold up. If she was improperly served, or she wanted to quibble and bicker about the name, the ultimate outcome is going to be nothing. Like, it's not going to be profitable. Like, if you get this summons and they sent it to the wrong address, well, you could argue that you were improperly served, but what they do is they just issue a bench warrant and arrest you, drag your ass in. And then you go in and your defense is that you were improperly served. So, like, some of these things, if you get notice of it, you can be a pain in the ass and try and fight it. Like, she could probably be a pain in the ass and try and fight about her name, but like, what good is it going to do? They're not going to be like, oh, you know what? You're right. That's the wrong name. Here you go. You win forever. That's not how it works. The law has, people talk about technicalities, getting off on technicalities. You're never getting off on a technicality. You're getting off on a rule. There's a difference. Getting off on a technicality would be they sent it to the wrong P.O. box. You're no longer like, you're not going to go through the process of being charged because of that minor mix up. It's like, well, no, they just send a new one to the right P.O. box. So the court is very correcting of technicalities. It's one of the reasons I hate that expression. I think a lot of defense lawyers do, because it trivializes what's happening. If someone's winning on a technicality, they're winning because the government broke the rules that the government has to keep you safe from the government. Those rules are often called rights or liberties, but sometimes they're just regulatory rules that the government must follow. as well. They're not always boiling down to a right, but it's not a technicality. It's a really fucking important thing that exists. And if you minimize it to a technicality, then you're a bootlicking statist pile of trash. And you should be thrown into a furnace or something. I think they tried that in a different country. But you don't, please just start reframing your mind on the technicality thing for all of our sakes, because the amount of Karening that's going on in the world right now is trying to eliminate technicalities. And those technicalities are your rights. That's the thing that is supposed to prevent crazy shit from happening to you. But here we go. Charge of 5th degree possession, schedule 1, 2, 3, 4, not a small amount of marijuana, felony amount. Not a small amount of marijuana is this is kind of a holdover of how the law was written, because Minnesota had decriminalized marijuana. So if you had a small amount for personal use prior to last year, I think it was, then it was a small amount was a non-criminal act. It was still a crime, but we don't have to get into it. But if you've got more than a small amount of marijuana, you had a felony. Now that part is really it's really not a small amount. They upped the amounts quite a bit. But we don't need to get into that, because she is accused of possessing more than 0.25 grams of cocaine, which is what brings us into the felony level. If it's less than 0.25 grams of cocaine, it would be a misdemeanor or gross misdemeanor, I think. Who cares? So here's the probable cause statement. And I'm reading the probable cause statement. I was going to go through the fucking motion. Let's do them both. What else are we doing? Grifty says, there's gold to be mined in reviewing the bad takes, no filter and no regrets. If when you beat this, I can only hope. Glad y'all are well. Thank you. Jake CB says, here's $5 for the lulls. Glad you're back on the air. Hey, thank you. Thank you. Glad to be back. We'll go through both the statement of probable cause and the motion, because I think it'll be helpful to have them both. Those Almond says, does April being charged lessen the burden of some quantity in yours and Kayla's cases below felony threshold, perhaps? Well, see, this is where it gets kind of tough to talk about things. We'll have to see. Minnesota has a couple different theories of possession, and one of those theories is joint possession. It's where multiple people can own all of something at the same time. And all of those people can be individually guilty or not guilty of owning a thing, any portion or all of it. And one person can be guilty of owning 100% of it, and so can another. That's how joint ownership ends up working. It's kind of weird in concept, but part of the problem here is, and this is what's brought up in the motion, is there's no particularity to the actual probable cause statement. So from this probable cause statement, we have to try and figure out what actually April is accused of possessing. So let's see if we can do it. The complainant states that the following facts establish probable cause. Your complainant is a licensed peace officer, is employed by the Candiota County Sheriff's Office. In this capacity, your complainant believes the following is true and correct. Who wrote this? Is this Brannis? Who wrote this one? Oh, no, it's Kent Bauman. This is the chief deputy. This guy was at my house. He was walking around being chunky. Like, when you're the chief deputy, you don't have to be as in good a shape as the other ones. Oh, that shape is almost universally round, to be clear. Did you guys ever see SWAT? Remember how LL Cool J looked when he was all jacked out of his mind? He's got like a 9-pack of abs. None of these guys look like this. All of these guys look like day old jelly donuts. Okay, so on May 23rd, 2024, at approximately 9:13 a.m., a search warrant was executed at, oh no, there's my house. Me and Kayla reside at the residence. As law enforcement approached the residence, Nicholas was traveling southbound on 51st in a vehicle. I was traveling southbound on 51st in a vehicle. Interestingly, I was not home. Nicholas Recato was stopped by law enforcement. That is not quite true, actually. I'll tell you the real story, guys. I saw a fuckload of cars going by that all said sheriff on them, and I thought my house was being swatted. So I pulled over and stopped on my own. I was not stopped by law enforcement. When I stopped, I saw a law enforcement car turn around and come back to me. So I waited for them there. They act like they stopped me. These lazy asses didn't do shit. Upon knocking on the door, a juvenile female opened the door and wouldn't let me in. This is false. Straight out false. A juvenile female did not open the door at all. I don't know why they wrote that down, but okay. Nicholas Rekieta would not provide the door code to enter the residence. That's true. I just said, show me the warrant and I'll give you the code. I'll walk you in myself. But they didn't want to do that. I wasn't there, to be clear. Again, they kind of are. These complaints are written in this real muddy sort of way. And I'm not sure why. Like, they can't just write clearly about what happened. But law enforcement entered the home utilizing a door ram and a big boy wielding it. Upon entry, law enforcement located Kayla Rekieta and April Imholt, and 4 juveniles were also in the home. That's not true either. Good job, guys. Got that one wrong as well. There were only 3 juveniles in the home. Kayla Rekieta and Imholt were located in the master bedroom. Officers noted the home was extremely cluttered. There were clothes everywhere, dirty dishes, dust, and an overall dirty home. It's almost like people lived there. Nicholas Rekieta returned to the home with law enforcement. I returned to the home? I went to the home with law enforcement. He demanded a copy of search warrant. I forgot the article. When given a copy, he looked at it and threw it on the ground. That's true. During the search, law enforcement located the following in the master bedroom. Following items are located in the master bedroom near the nightstand. This is interesting because this is a lot about me. April is not the star of this show. Yellow snort tube, positive for cocaine. Black vial with white substance inside that field tested positive for cocaine and weighed 2.2 grams. That's a run-on sentence. 2 credit cards listed to Imholt. The yellow snort tube and the black vial containing cocaine were found directly on top of the credit cards. 2 .22 caliber spent shell casings on the floor of the nightstand in the master bedroom. Guys, one day I'm going to show you all about those shell casings. It's kind of funny. It's funny because they're like, we're going to take your kids. And I'm like, I don't even have a 22, you dumb fuckers. It's just from art. The following item was located underneath the bed in the master bedroom. 6-hour AR with several magazines and loose ammunition. Serial number, whatever. Following item was located in the master bedroom dresser. Glass container with metal filter and grinder and glass container that field tested positive for cocaine. The following items were located in a safe in the master bathroom. Bag with cards and dollar bill that field tested positive for cocaine. Large corner cut baggie with white powder that field tested positive for cocaine and weighed 18.96 grams of packaging. 3 small baggies that field tested positive for cocaine and weighed 5.49 grams of packaging. 8 green colored tablets that field tested positive for ketamine. Digital scale that field tested positive for cocaine. Metal pan with white powder on it that tested positive for cocaine. 2 snort tubes and 2 metal cutters. Snort tubes tested positive for cocaine. Following items located in a safe in the master bedroom closet. This is all alleged by the county, by the way. I'm not admitting to any of this shit. This is their list. $100 bill with white powder residue that field tested positive for cocaine. Bindle white bag. What's a bindle white bag? With white powder substance that field tested positive for cocaine. Cocaine scooper. So like a pooper scooper? Like, the things that you pick up dog shit with, like little claw thing? What is that? 2 baggies with a baggie. 2 baggies within a baggie with a funnel. That's confusing. Unknown brown substance. Oh, I hope it's poop. Additional firearms and ammunition were located in the garage. Imholt's purse was located in the hallway inside the master bedroom, leading to the attached bathroom. The total amount of measurable cocaine in the master bedroom was 26.67 grams with packaging. It's a big package. Cocaine is a Schedule 2 controlled substance. Ketamine is a Schedule 1 controlled substance. That's not true. Ketamine is a Schedule 3 controlled substance. Good job, drug recognition experts and sheriff of the county that I'm in. Detective Pomplin, this guy's a winner, met with Nicholas Rekieta outside the residence. He was read his Miranda rights, and he agreed to speak to officers without counsel. Nicholas Rekieta indicated that he sleeps in the master bedroom with Kayla Rekieta. He indicated that Imholt was at the home visiting. Nicholas Rekieta and Kayla Rekieta were placed under arrest. While being placed under arrest, Detective Pomplin noted several injuries to the arms of Nicholas Rekieta that appeared consistent with sores that are common with controlled substance users. No, they did not. They were It's funny because one of the pictures that they have of my sores on my arms, the guy handcuffing me has a sore on his arm because some people get sores on their arms, but okay. They're transported to the Candy, Ohio County Jail. Kayla did not speak with officers. At the Candy, Ohio County Jail, Nicholas Recato was again read his Miranda rights. I got Miranda twice. And agreed to speak with officers without an attorney. Nicholas Recato refused to answer any questions regarding cocaine or other controlled substance use. Nicholas Recato indicates that he lives in the residence. He stays in the master bedroom with his wife, Kayla Recato. Imhold was a friend who was visiting and does not live at the residence. While being booked into the jail, Kayla Recato requested that her prescription medication be brought to her. Upon reviewing the prescription bottles for Kayla Recato that were brought to the jail staff found 2 unknown pills and gummies in one of the prescription bottles. 2 unknown pills and gummies. Okay, both of those are plural, but they're different things. But there's 2. That's confusing. These items did not match the prescription on the bottle. Kayla Recato informed child protection workers that Imholt is their live-in nanny. This is not a true statement by the drafting officer here. If you go back and read my complaint, this is a fun game of that insular telephone that we're talking about here. This is one of the instances where it happens. It happens in another place too, but Kayla did not inform a child protection worker that Imholt is a live-in nanny. A child protection worker asked Kayla, according to the other complaint, what the status of our live-in nanny, Cheney, actually, what the status of our nanny was, our former nanny, Cheney, who she described as basically a live-in nanny. The CPS worker did. Kayla indicated that April was our nanny, and the CPS worker took that and made that into April being a live-in nanny. She did not say she was the live-in nanny because we have never had a live-in nanny, ever. Our former nanny was not a live-in nanny. April is not a live-in nanny. We don't have a bedroom for a live-in nanny. All our bedrooms are full of kids. So, that being said, this is one of those things, though. It gets put in the complaint that this is what is said. That's not what was said. That is what the CPS worker decided to label our former nanny as, even though she never lived in our home at all. She says, technically or basically, I can't remember the exact wording, but it's either technically or basically a live-in nanny. And then that gets put onto Kayla as her making this claim, but that didn't happen. But of course, now what has happened? The officers have used that statement in part as a basis for bringing this charge. So here we have a government worker. And again, this isn't like some malicious lie, right? This is some statement. I mean, maybe it is. I don't know. I'm not going to accuse her of that at this point. She lies in other places plenty of times. But giving her the benefit of the doubt, this is a statement where she's like, well, you guys have like a nanny or whatever, right? Like a live-in or something. And then, because that's not our nanny. Actually, April over there is our nanny. She replaced the former one. She goes, oh, so the CPS worker goes, that's the live-in nanny, and writes it down. That becomes now a fact, but it's not a real fact. It's great. So please take notice, pursuant to Minnesota Statute 609.49, intentional failure to appear for duly scheduled court appearances may result in additional criminal charges in addition to any arrest warrant that may otherwise be issued by the court. This is weird, because what do you guys see where the crime is? I know you can find, you can try and find a crime like in these facts. You can say, okay, well, here, this might be a crime. This might be a crime. This might be a crime. Where's the actual accusation in this statement of probable cause? They say in the complaint that she's accused of owning more than 1/4 gram of cocaine. Well, they've got a couple different alleged sets of cocaine to choose from. Which one is it? And herein lies the problem. What is she accused of owning? So this is where you come into having the motion to dismiss, which I'll have to pull up because I didn't grab it just a second ago. See if I can get it now. Oh, why is case search down? Hold on. Let me see if I can. I think I have it on here somewhere. Mm-mm-mm. I know I had that fucking document. Damn it. This is down. I don't know if I'll be able to pull it up right now. Maybe someone can send it to me or I can find it somewhere. But hold on, there's a couple more chats. But yeah, I wanted to get into that live-in nanny part because it's this interesting place where the county's created this. And again, it's not necessarily nefarious. It's not like they went in there like, we're going to plan to live in nanny in their house. Like that's weird, right? Could be helpful for some people, but that's weird if the county were to do that. They didn't have to, right? They have just a little inaccuracy, this minor inaccuracy where someone uses, again, a common vernacular of a live-in. But if you don't have a live-in, someone says, oh, is that a live-in nanny? And you're like, well, kind of, or whatever. Like someone, you might do that. And it doesn't matter normally, right? Because who cares if you label someone a live-in or not normally. Now, though, that label has partially resulted in these charges. So it's kind of fun. It's fun how crime works. Oh, my God. Vaz Kalma says, how come the only women you can get are women you're giving money to? Stop pay pigging for April and watch how fast she scrams. Meep, meep. Oh, boy. All right, my friend. Sounds good. Carasola X. Nick, your house from an aerial view looks like a bent manhood. It's just not excited right now. You leave him alone. Lol, also, Birchmore wasn't just groomed. She got Epsteined even though cop caught on camera. Well, you're making my faith in the state just run wild. Gino says, you have a brilliant legal mind. Uh-oh, I'm waiting for the but. We need you to analyze and give us your insight. Example, Rittenhouse. I find it disgusting. Attorneys grifting off your case. Oh, okay. Wait, what do you want me to analyze and give you insight on? My case? I want to. I can't, though. Grifty says, I'm sure you can find it on Kiwi Farms. I can. I'm sure. Yeah. No, I think I got it here. Just a second. Anime Sucks Copen Sneed says, Nick, a conundrum has occurred. Do you think a general discussion thread centered around AI art of morbidly obese furries and scalies should allow morbidly obese furries and scalies farting? Yes or no? Morbidly obese and furries and scalies, the farting has to happen. Otherwise, it's just not reality. You can't AI farting away from furries. Okay. And you know that. You know that. God. Have they invented enough gas for the furries yet? Hold on. I think I've got it in email here. Oh my God. So what happens when you don't check your email very often? Oh, there. I think we got it. Friends, here's the motion to dismiss. Sorry for my lack of preparedness. Like I said, my overall disorganization is just going to come through heavy today. It's an ADD heavy day for me. I've been engaging in activity that is emotionally fucking just draining. It's not even like some of it's really sad, but that's not what I was talking about, actually. There's plenty of sad things that happen all the time. But no, it's just fucking tiring shit you have to go through. And you have to go through it. And it's like, well, I don't want to go do anything else. Sound like a baby. I want to do something else. Darn Bungholio says, should your furry outfit have balls or no balls? You know the answer to that. Always balls. It's weird without balls. Guys, would you trust a furry without balls? I wouldn't. Doesn't mean I'd trust a furry with balls either. Motion to dismiss complaint. Okay, so getting back into this. At your first appearance, generally speaking, what happens is this. At your first appearance, they go in, they make sure that you understand that you're charged with a crime and what crime you're charged with. You can even have the court read the entire complaint, like we just did, out loud on the record, if you want them to. If you, for some people, maybe they have literacy problems or whatever, they may actually need the complaint read to them to help them understand what's going on. Generally speaking, people are going to waive that because it takes a lot of time. And you enter a plea of either guilty sometimes or not guilty most of the time. And then you get to scheduling the next hearing. That's about all you really have to do at most first appearances. On occasion, an attorney may find it useful to file a motion to dismiss. If they believe there's sufficient grounds to dismiss a complaint outright at the beginning, they'll file a motion to dismiss. Now, this usually does not actually resolve the case, even if you win. It does dismiss the complaint itself, and the government would have to then refile if they wanted to go after you. And it can be dismissed with prejudice, but oftentimes they'll just dismiss it without prejudice and allow the government the opportunity to amend the complaint, offer more clarity. Now, if it's clear that the government doesn't have access to the facts to actually support any kind of claim, a judge may dismiss it outright with prejudice and say, okay, yeah, you got nothing. But if they find that there are sufficient facts and maybe there just needs to be more particular wording, they can offer the state the opportunity to rectify the problem. But because you really aren't typically winning this motion and winning the case, it doesn't really hang around. It doesn't really come up as often because usually you're going to just wait until your Rule 11 omnibus hearing in which you would make your pretrial challenges. That's what I'm in the process of right now, is that you would go to your Rule 11 hearing, and that's when you challenge probable cause for the charges, probable cause for the warrant, et cetera, et cetera. Any of those dispositive motions are resolved there typically. You're also, at that point, you're going to have some discovery come through and things are going to kind of be rolling. And that's why it's a little bit better position to go after this. And that's what ended up happening here. The judge basically said, probably want to refile this around the omnibus time. Thinks it's a little premature here. I actually disagree with the judge, but not in a harsh way. I mean, there's no practical impact to the decision going this way, so it's not that big of a deal. But I disagree. I think that this complaint is facially deficient, and I think the motion here is correctly argued. When we watched the video, there's some things that I thought maybe could have been brought up. Now, I'm not criticizing her lawyer at all. He seems like a cool dude, but it's there's some things that could maybe be brought up that I'll, if I remember them, I'll try and mention them as we go. But he really doesn't. There's not like a big fight that goes on because you don't really need to have a huge fight here. What he gets out of this is immediately apparent, and we'll talk about it in a minute. Okay, so here we go. This is a motion to dismiss. The defendant, April, through her attorney, Thomas Gallagher, and pursuant to Minnesota Rules of Criminal Procedure 11.03, hereby moves to dismiss the complaint. This motion is based on the files, records, and proceedings herein and on the following grounds. Complaint does not comply with Rules of Criminal Procedure 2.01. Complaint fails to allege facts amounting to probable cause to believe that an offense was committed. This actually right here is true because it just doesn't say which facts actually show any kind of possession. They leave a couple breadcrumbs, but the complaint fails to establish probable cause to believe the defendant committed an offense. There's another one, like even if you can find an offense committed in the fact pattern, it doesn't say that April committed the offense. And then fourth, further moves the court pursuant to 5th and 6th Amendments to the U.S. Constitution for an order dismissing the complaint for lack of sufficiency or in the alternative requiring the government to furnish defendant with a bill of particulars. Now, none of this was granted by the judge, but it doesn't matter Like, again, the judge didn't order a bill of particulars, but the government does, or the state does clarify their position on what April is alleged to own in this case. So we actually do get some of that information out of this hearing. But here we go. So here's the rule. It sets forth the content requirements for complaints. Now, again, think back on the complaint we just read and see if it meets this in your opinion. Maybe it does. The complaint is a written signed statement of the facts establishing probable cause to believe that the charged offense has been committed and that the defendant committed it, except as modified by Rule 6.01, Subdivision 4. The probable cause statement can be supplemented by supporting affidavits, statements signed under penalty of perjury pursuant to Minnesota statutes, sections 358.116, or by sworn witness testimony taken by the issuing judge. The complaint must specify the offense charged, the statute allegedly violated, and the maximum penalty. The complaint must also conform to the requirements in Rule 17.02. And here's the comment to that rule. Because the complaint is accessible to the public and documents supporting the statement of probable cause can contain irrelevant material that is injurious to innocent third persons, as well as material prejudicial to the defendant's right to a fair trial, it is recommended that a statement be drafted containing the facts establishing probable cause in or with the complaint, and the irrelevant material be omitted. Now, interestingly, most of this complaint is actually irrelevant, right? April is charged, as we'll find out from the actual hearing, she's charged with owning this alleged 2.2 grams from a black vial located in the bedroom. The government did not allege that she was charged with ownership of anything that was allegedly pulled from the safe from the master bathroom. Okay. So in this now, we have a big question. Well, why the fuck do you talk about the safe and what's in it and all of the other stuff involving the house? Like, why is that relevant to April being charged with owning this one thing from one spot? In my opinion, this complaint does not conform to the rules. However, we get into the practicality part of it here, right? The practicality part is, are we achieving the goal? Now there's more particularity to the allegation. The specific alleged controlled substance has been identified, and now that information is available to the defendant. So we've achieved that goal through this hearing, even though the complaint, in my opinion, is facially deficient. The complaint alleges a criminal violation of felony possession of controlled substances, 5th degree, and contains 2.5-page statement of probable cause alleging various facts to be true. Defendant's name is mentioned only 5 times in the statement of probable cause. I think some people have quibbled on this and said it's 6. I didn't check. I don't care. If it's 5 or 6, it's still pretty. Well, the 6th one, that makes it reasonable. The statute charged requires unlawful possession. Minnesota statute 152.025 subdivision 2, parenthetical 1. But the complaint does not allege facts to be true that defendant unlawfully or otherwise possessed illegal drugs. It only says that she was a guest in someone else's home when police executed a search warrant and found illegal drugs. Accordingly, since the complaint contains no factual substantiation or probable cause, it must be dismissed. It's important to note that the complaint doesn't say she is in possession of anything in there. Like, they just don't say it, which is weird. I don't know why they didn't just write that down. Like, if you're going to allege that she's in possession of a thing, which is, you're charging her with the crime of it, I think it's safe to allege it. You don't have to be scared. Like, they should just write it, but it's just bad writing. Probable cause exists when a person of ordinary care and prudence, viewing the totality of circumstances objectively, would entertain an honest and strong suspicion that a specific individual has committed a crime. Again, it has to be a specific individual and a specific act. A person's mere proximity to criminal activity does not in and of itself establish probable cause to arrest. Since the complaint makes no allegation the defendant possessed any illegal drugs, but merely she was present in the same house, it should be dismissed for lack of probable cause. The 5th and 6th Amendments require that a complaint sufficiently apprise the defendant of what he must be prepared to meet. This is Russell v. U.S. This is well-established criminal procedure case law is what he's going to go through with Russell and Hernandez, Wessel. These are all like landmark cases in this coming through. Well, some of these are coming through the appeals courts. Others, Russell here, Supreme Court. The complaint provides insufficient information to allow a defendant to form a defense and should be dismissed. At a minimum, she's entitled to a bill of particulars ordering the government to clarify the charges with details sufficient for her to understand and respond to them. A bill of particulars serves to inform the defendant of the nature of the charge against him with sufficient precision to enable him to prepare for trial, to avoid or minimize the danger of surprise. If you say surprise at trial, and enable him to plead his acquittal or conviction in bar of another prosecution for the same offense when the complaint is too vague and indefinite. U.S. v. Hernandez, see also U.S. v. Wessel. The district court, in its discretion, may order the government to provide requested additional detail where the particulars set out in the complaint fail, sufficiently to apprise the defendant of the charges to enable him to prepare a full defense. That's U.S. v. Garrett. The complaint alone will be sufficient when the elements of the offense are delineated and the general statement is accompanied by specific facts constituting the offense. That's U.S. v. Helmel. It's axiomatic that a defendant is entitled to know what behavior is alleged to constitute the defense he is charged with. U.S. versus Idris. And then that's ordering a bill of particulars detailing the elements of 3 counts of the specific facts establishing those offenses. The defendant, for the reasons respectfully requests the court grant her motion to dismiss the complaint for lack of probable cause. And that's signed by Thomas Gallagher. Okay. Sorry, we kind of burned through that. But this is just an outright shot across the bow, right? Like, you're not doing your job well. There's a whole lot of reasons that the DA may not be doing their job well. DA, I say DA, it's county attorney, assistant county attorney. But the assistant county attorney may not be doing their job well for a lot of things. Like, I won't get too deep into speculation. I know you guys are smart and we'll figure out some reasons why that might be, but I have reasons to not talk about it. Unfortunately, boring. But there are some reasons why this just might not be a well-drafted complaint. And frankly, this motion kind of sets the tone, right? Hey, let's get fucking gear here. Like, let's figure this out. You can't just generally allege some criminal activity has occurred without saying what it actually was. We're going to watch that video as soon as I pull it up, and then that will give us kind of the next step in what that activity is, with where the government gets it more particular. But I want to point out something here as we go. I know this is kind of all together, but let's see. Oh, I gotta get this. The hearing itself. And we'll pull this thing up. Is this one going to work? Here we go. Oh my God. Okay, it looks like we've got some fucking weirdo thing here. This is a video by Greg Edwards. He's got the Zoom call. We'll use this one. I'll link it in the description so that people can pull it up themselves. Hold on, let me get this here. Get everything ready. But sorry, it kind of gets all these things jumbled together, but we need them close in proximity so we can actually analyze what happens. Because I want to point out another subtle lie that happened. And again, it matters. This is an actual thing that ends up having an impact. And I want to show you guys how government just fucks you in little ways over and over again. Because, well, that's what they do. Disciple of Dagon says, much love from the biggest problem in the universe fan base. Many prayers. Hey, thanks, man. Hope you guys are doing well over there. Grifty says, what is alleged total weight versus April's versus yours? Well, it's tough. The alleged total weight was 26.67, I think. But that includes packaging. And the weight that is alleged to belong to April, I believe, is a 2.2 gram amount, which would assume include packaging as well. But that's really kind of unclear. Nick Rye says, has it been established who April is in relation to you? Employee, friend, lover, wife's lover, something else? Ooh, has it been established? I don't think so. Has it been established? I don't know. What do you guys think? That's probably a mistake. You guys don't answer that. What do you think? I don't know, man. It depends on what your definition of established is. Like, and I don't mean that in a shitty Bill Clinton way. I mean that in a way of like, who do you need it to be established for? Because we're not at trial. So, oh wait, he kept muting April's lawyer. Oh, God damn it. I can find a different video. Hold on. Why are people bad at the things they're supposed to do? Just do the things that I can't, please. Do them easier. It depends on what you mean by like, is it established? Like, we're not at trial. So it doesn't have to be established in any way for the court at this point. Anything in regards to the court right now, all facts as they exist are alleged. There's no fact finder right now. We don't have a jury. Juries are fact finders, or judges in a bench trial are fact finders. Since we don't have an actual fact finder appointed in any of the cases yet, we don't have any way to establish facts for the purposes of court. So right now, anything and everything is simply alleged. Alleged. Hold on. Do we have? There's got to be a better one from today. Aren't there like a million of these fucking things today? Oh, here we go. Oh. Well, maybe we'll just use this one. But if it has our lawyer muted, that's going to be fucking annoying. I wonder if that Will Heron guy has it. Somebody did their fucking job, I hope. Nope. Terrible. Will Heron, that was garbage of you. Very unhappy with that. Does Stalin have it? I don't know. I should have found this, but like I said, I was on the verge of just not. Okay. Videos. Somebody's got to have a raw fucking video of this thing. Win by 2 has it, but not like the. I should probably read. Hey, what's up, Tug? Does anybody know which channel has just a fucking raw video of this? Let's see. Let's see. I mean, I guess we'll just do this. This one. This will work. We got it from Stalin here. Allegan News says, remember everything you're saying will and can be played in court. You are the party to the matter. I mean, I'm not. Necessarily yet. I guess it's possible that I could be. Now, in my matter, I'm a party to the matter. I'm not a party to April's matter. So anything I say might be played in court. Might, but it might also be hearsay. Now, there's a whole lot of ways in which that can get really fucking muddy. But for now, let's just go with, I know I'm not really that concerned with what I'm saying today. Yeah, actually, if they would like to play the part where I point out where the government lies, like if they would like to play that part of the video, that'll be okay. I'll allow it. I'll even not copyright claim the court. Okay, so here we go, guys. Let's watch this. This is Judge Fisher. Who never mind.
487 State versus April Imholt. Note the appearance of Thomas.
Why did homeboy breathe like that? What was going on there? He went, it's like, is he okay?
Gallagher, attorney with and on behalf of the defendant, April Imholt. Kristen Pierce, county attorney, appears on behalf of the state. This is
that's an allegation. You can't prove that's my studio.
Of possession of controlled substance, a felony violation of Minnesota statute section 152.025, subdivision 2, paragraph 1, and subdivision 4, paragraph B. Maximum penalty 5 years imprisonment, a $10,000 fine, or both. Ms. Imholt, you have the right to remain silent and not submit to police interrogation. Anything you say may be used against you in this or any.
It's kind of funny that she would Mirandize April during this hearing and say she has the right to remain silent, because like the officers did that and then they just ignored it. So that was cool. Good job on that one. Get back to this in just a second here. What the hell? Okay. All right, back to this.
Any subsequent proceeding. You have the right to counsel in all proceedings, including police lineups and interrogations. You have the right to be represented by an attorney of your own choosing.
April is very blurry in this. She looks like that Scanner Darkly movie with, I think it was with Keanu Reeves. They had that weird animation style.
Your own
expense. Oh, the guy in the bottom
However,
left is a guy named Win by Two. I don't know.
Indigence, then attorney will be appointed at public expense. You have the right to communicate with defense counsel, and a continuance will be granted if necessary to permit this. You have the right to a trial before the court or a jury. Mr. Gallagher has submitted a certificate of representation. Mr. Gallagher, you've also submitted a motion to dismiss, and it's your motion.
It's my
Your Honor,
motion.
when I looked at the complaint, I'm asking the court to dismiss the complaint today based on Rule 17.06 subdivision 2.
Okay, so I'm kind of ignoring this first part, like I'm playing it for posterity, but we just went through his motion, so we know what he's doing. What I'm interested in talking with you guys about is what Kristen Pierce, county attorney, has to say in response to him. And also, one of my just general complaints for the court, where prosecutors get to do lawyering on easy mode and they have no fucking rules or standards that they have to follow. It's pretty amazing. Indiana the Dog says, Nicholas, I've been away for a few months on a silent retreat. What's up with you and and the lawyerings? Oh, it's so much. Did Trump drop out and go to jail yet? Did I miss anything? No, you missed nothing. Everything is normal. It's January. Palmyra Productions says, Nick, tell Kayla, Amanda, Adriana, and Cassandra all wish her well and to stay strong. I've asked him not to contact her. I have to think about my business, but I also won't stop them. Hope all is. I've asked him not to contact her. I don't know who you're talking about with those, but I will tell Kayla that Amanda, Adriana, and Cassandra do wish her well. Thank you.
Paren 2, Paren D, and subdivision 3. And as outlined in that rule and in the comment to that rule, if the facts alleged in the complaint do not constitute an offense, then the complaint should be dismissed. And that can be raised at any point in the proceedings, including today. The complaint, the probable cause section, I believe, is about 2.5 pages long. It mentions the defendant's name. There, I believe I put it in my motion, but in writing, but it's 5 times her name is mentioned. The first time it says she was located in the home. The second time it says she was located in the master bedroom. Third time it says 2 credit cards listed to the defendant were found. And then it says the fourth time it mentions her name. It says her purse was located in a hallway between the master bedroom leading to the attached bathroom, and that a co-defendant indicated her
background does not look familiar, you liars. What are you talking about? I'm just kidding. Obviously, she was sitting right here.
Homeowner indicated that the defendant was at the home visiting at the time of the search warrant execution. Mere presence is not enough to support a possession charge. There's no allegation that she possessed any drugs. And so we're asking that the court dismiss the charge.
Ms. Pierce.
Your Honor, Ms. Imholt was found in the room where the drugs were found. She's only being charged with the drugs that were found immediately on top of her credit cards, which were active and not expired. One was a bank card, and
Okay, so here's where we get into the meat of this, and this is where it starts to like matter what's being said a little bit more. I mean, the other stuff mattered, but we went through it in the paper motion, so we didn't really need to hear Mr. Gallagher's words, as eloquent and wonderful as they were. We've just now gotten that she's only being charged with the amount that was, quote, directly on top of the cards. And this fact becomes pretty interesting in just a second, because you're about to hear a lie from Miss Pierce.
and her purse was found in the master bedroom suite.
Okay, so real quick, sorry, I just have to do this again. If you're next to drugs, but they're not your drugs, and you don't know that they're there, you don't own drugs. Okay, so this is a kind of a, like, possession is not just you're around something. So if you take the allegations of the search warrant execution, the complaint is true, and you say that there's this controlled substance, and April's in this room, then they go, well, you still have to prove that there's possession. So you can't just like be like, well, they're there. And that's what the complaint was. The complaint was, this was there, April was here, therefore, but except they left out the therefore. So we're now finally getting it. But they're saying that this vial that tested positive for cocaine was sitting on top of a couple credit cards, on top of a nightstand, and therefore April is in possession of that. That's their claim. Now, this gets legally wonky in a bit.
Which between the master bedroom and the bathroom. And she was in the room when law enforcement executed the search warrant, and the drugs were out in the open on top of her immediate possessions with the rest of the
That is not accurate to the police report. And that's an interesting thing there. That is the first time and only time that I'm aware that the state has claimed that the drugs were out in the open. Miss Pierce has misrepresented a material fact right to the court. At least if we're to believe the complaint, because the complaint, let me just go back to what it says. The complaint says, following items were located in the master bedroom near the nightstand, black vial with white substance inside that field tested positive for cocaine and weighed 2.2 grams. That's not out in the open. And the reason that matters is because there's an actual statute in Minnesota that says if drugs are out in the open, then anyone in the room is presumptively in possession of them. It avoids this problem that you can kind of imagine in a hypothetical scenario where there's like a mountain of meth, right, on a table, and there's like 10 people all standing around, and they all go, it's that one's, like, it's that someone else's meth, right? Like everybody's pointing at everybody else's meth. They do the Spider-Man thing. His meth, his meth, his. Minnesota created a law that says if drugs are out in the open, then everyone who's in the presence of them is presumptively in possession of it at the time for the purposes of the statute. And so this is interesting because without that fact, it's possible this complaint is deficient on its face, and it's possible that this complaint is deficient as it still stands, because they're not out in the open. So there's nothing here then establishing possession. They could maybe try, again, maybe they have different facts. I don't know. But from what they've put in the complaint, there's nothing. First of all, they don't even allege the possession, but there's nothing actually establishing the possession by April. The only thing that would be establishing it would be this out in the open sort of comment, puts it presumptively under the possession because of that special statute. And this is one of those things where This is a lie. Like this is an officer of the court. This is the prosecutor in this case. And she's representing to the court that this was different than what is in the actual complaint. You know, that's fine though, right? Like it's just a felony charge. it's just the government telling people that you did something illegal. What's it matter if they just have the facts incorrect? Right? Like what's that matter? But they do it. And it's not really a polite or useful way to bring this up. That's what makes it difficult as well. I mean, I guess Mr. Gallagher could have objected here. Does he win much from the objection? I'm not quite sure. But what he does now have, in my opinion, is actually this nice piece of ammunition. Because I don't think an objection here actually wins him the case all around. But having the prosecutor now misrepresented the facts on the record, that's a fucking arrow in the quiver.
Contents of her purse also in that room. While mere presence is not enough, that does show.
And actually, there was a subsequent one. If you go through that complaint again, that statement of probable cause, the contents of the purse are not in that room. The contents of the purse are in the purse, which is kind of a weird sort of misrepresentation that is done by the government actor here. And I'm just not quite sure why they would go ahead and do that. But hey, you know,
that she was in the room and creates a joint possession that she was using, or at least with one of the homeowners in that bedroom where the drugs were out in the open, on top of literally on top of her property, of her bank cards.
There's that in the open thing, not in the criminal complaint at all.
Huh?
Why is he confused?
For today's purposes, I'm denying the motion without prejudice.
Denied.
I think the motion is not as simple as the defense filing would make it seem, considering Ms. Pierce's take on the evidence, and that the motion to dismiss would be more appropriate for a Rule 11 motion where the parties could dive in a little deeper to present the court with the full flavor of the evidence. And so for today's purposes, it's denied. And Mr. Gallagher, would you like to combine Rule 5 and Rule 8 today?
So there you go. Read out the criminal complaint. Like I did.
Yes.
I did just a
All
second
right,
ago.
are you
weirdo.
waiving reading of the complaint, deferring entry of a plea, and demanding an omnibus hearing?
Lock her up.
Yes.
And are you wanting the contested omnibus hearing right away? Or do you want to be on the uncontested block first?
I think we'd
Another win for the
rather be
show.
on the uncontested block because every now and then discovery issues pop up.
Yep, and that's fine. The purpose in our county for the uncontested omnibus is for the defendant to either demand or waive the contested omnibus. So it does buy you a little time, and then the case is not assigned. We'll assign it once you demand or waive omnibus.
I can't get over she's in Nick's studio. Oh, poor Abe. She's gonna cry.
AJME CD says, wait, the prosecutor said she was a user because she was in a room where there were suspected drugs. That doesn't make sense. That's, some people would say that doesn't make sense. Stephen Crater says, did you see that a Candy, Ohio County deputy was charged with DWI after rolling a squad car multiple times on August 14th? I did. He was not, as far as I'm aware, he was not one of the deputies that was involved in my situation. I wish him a speedy recovery and a swift prosecution for driving under the influence. Seems kind of like he shouldn't do that, I would think. Crass Cat. Your super chat was deleted. What did it say? I wonder if I can. I don't think it can. I don't think it's going to show me. Damn. Aw. Okay, stop clicking on things. Oh my gosh. Well, so there we go. Can I get a minute? Sorry, Crass Cat. I'm not sure what your message was, but yeah, here we'll see what. There's not much left. They're going to go through the release conditions.
September 17th at 2:30.
That's out of 14 days.
Oh, sorry.
Would be the 11th at 2:45.
We would
September
waive any
11th.
time
Oh,
2
limits,
weeks.
by the way.
gosh, I'm thinking, I'm totally sorry. My fault.
Yeah, you're being
Okay,
watched.
time is waived, so
Judge.
the 17th, a lot of our prosecutors are gone.
Okay, I'm not going to sit here and do this actually because it's getting annoying. Look, long story short, they schedule it out and then it goes into the rest of it's uninteresting to me. I'll just summarize. They go into the terms of release. Obviously, this was by Zoom, and clearly, April was attending from the Candy Ojai County Jail, as you can tell by the blurred background. But because of that, the release conditions were set by the judge as a $20,000 unconditional release bail, or release conditions, which would be released on your own recognizance, stay in contact with your attorney, no leaving the state without permission, remain law abiding, and then importantly, a no ownership or use of mood altering substances, including alcohol, which is a standard. If you have a case involving any substance from DUI to possession to sales, they will have a restriction on use of any controlled substances or use of any mood altering substances. And it basically always includes alcohol. Personally, I think that's a little bit, I think that's a really shitty thing that they do, because if someone's charged with, use of, I don't know, fentanyl or whatever, their use of alcohol isn't related to the fentanyl use. So I don't see any nexus to do that, but they just blanket restrict everything. So that would be the conditions. So the way that bail works in Minnesota is you can either post the cash amount of $20,000, or you can get a bond. The bond would cost $2,000, and then a bonding agent would put up the bail money. If you post the full cash value upon your completion of your case, as long as you make it to all your hearings, you actually get that money back in full. If you post a bond, you're out the money that you spent on the bond. It's a trade-off for having to pay 10% less. But what I want you guys to do, just as an exercise, is go to your kitchen and get the sugar out, right? And get a teaspoon like that you would eat cereal with, and put about fill up a quarter to a half of that with sugar. And then say that amount of a substance amounts to $20,000 of bail. Remember that we haven't, people made fun of me for this because I just asserted, knowing that it wasn't going to change, but asserted that bail in my case, I believe, is excessive. $50,000 bail seems excessive for a first-time possession charge. But hey, that's my opinion, man, or whatever. April's is a 5th-degree possession charge, and I think a $20,000 bail is a little bit much for me. It's kind of wild to think that they're well, that seems reasonable. If you don't want to live under the government's restrictions of your liberty, you just pay $20,000. We'll give it back. If you're found guilty and you have a fine or any restitution, we'll take it out of that $20,000, and they know they're going to get it. So it's kind of like they might find a way to spend it, or award it, that might happen. But it's, to me, I just have a problem with the way we do bail on this stuff. Certain crimes, right? You have someone who's beating people or rapists, murderers, etc. Maybe you want some good bail in there, dangerous to society, but other bail, it's like the numbers are insane, especially when you think of generally who's being charged with, possession crimes. Typically you're dealing with low income people. $20,000 is an insurmountable number for most families out there to just have to come up with. So it's kind of wild to think that's how we do it. And of course it's only the 2,000 if you do a bond or whatever. In our case, it's only the 5,000 to do a bond, but it's like, I don't know a lot of people with that kind of money lying around. And plus you're paying lawyers and, you have other issues going on that you have to deal with. And it's it piles up like crazy. And I really do wonder, like the 8th Amendment, it says no unreasonable bail shall be set. And it's like, well, what actually is reasonable bail? We accept bail, but what is, like, conceptually, where is it? But kind of fun. Allegan News says you could save April and wife and admit all of it was yours. You could save all of us and admit all of it was yours. What do you, damn, why don't you try that one? Look, so here's the thing, guys. I wanted to do this because there's been this story floating around. This kind of came up the other day, and I actually, like I said, I saw this on Kiwi Farms, and it finally has kind of resolved itself, which is weird. People have accused me of confronting a judge. Actually, I believe they are accusing me of confronting that judge, Judge Fisher, in an elevator. I could safely say I don't recall ever being in an elevator with Judge Fisher, nor ever confronting Judge Fisher. But this is how this thing works. It's this insular telephone. Part of my falling out with Josh Moon from Kiwi Farms was trying to inform him of the insular telephone problem. I didn't have a witty name for it, but trying to inform him of the insular telephone problem on the farms, where a group of people will create something, and they'll morph a set of ideas into something that didn't exist before, but it will become factual. And in this case, it's a story I told, actually, yes, about Judge Fisher. It was the last criminal case I represented. And after that case was over, after the sentencing was done, which my client got the guideline sentence, the judge was not willing to turn that many felonies into a stay of adjudication. Shucks. I was hoping for it. Was really unlikely. But after that, one of the things the judge had said while dressing down my client during sentencing, which is something judges do, they give a life lesson to the person who's about to go to prison, because, like, I don't know, if I'm going to prison, right? If you're sentencing me and I'm going to go from the sentencing to prison, the last thing I'm thinking about, honestly, is like the heartfelt life lesson that the judge is giving me. That I'm not even trying to be rude. It's just not the thing that would be on my mind. But the judge is dressing down my client, and my client was charged with and pled guilty to stealing quite a large sum of money. And the judge took umbrage at one point with the idea that my client had paid for a private attorney. And, so judge had dressed her down for that. And the hearing was over, and my client was taken away. I was packing up my stuff. I was the last person in the courtroom. The judge re-entered the courtroom. Now, to be clear, I'm still at counsel table, and the judge is up at the bench. Like, I'm nowhere near this judge. When I just said, "Hey, judge, I didn't take a dime for the case. I did it for free." The judge seemed to be frustrated with my client for having the audacity to hire a private attorney while being accused of stealing money, which is not actually a proper criticism at all. But hey, but I informed the judge that I took the case pro bono, and she said, "Thanks for that." I don't know exactly what she meant by when she said thanks for that. I took it as kind of like I feel kind of like an asshole. Like that's how that's the kind of feel I got. Like, oh, I guess I was kind of an asshole for saying that. Wasn't going to change her opinion. I mean, she gave her the guideline sentence, so I don't think there was much impact there. But I thought it was improper, and I let the judge know that I took the case pro bono. I wasn't paid for it. So yeah, that was that. But what happened was one person on Kiwi Farms, like a year after I told this story, created the detail that I confronted this, or that this happened in an elevator. And then it became that I confronted this judge in an elevator. And then the story on Kiwi Farms most recently is that like I aggressively confronted a judge in an because this sounds like a reasonable thing for an attorney to do, is to aggressively confront a judge in an elevator, especially when I'm like a larger man and the judge is a smaller woman, height wise. Like we're talking about a pretty significant difference here. But the suggestion that I confronted this judge in an elevator and like aggressively berated her for this thing is fucking ludicrous. But this is people's headcanon on Kiwi Farms, like around me. Now, look, I'm not doing the thing where it's like, oh, Nick found this thing. He's gonna say that everything. No, it's just like this is an example. This is an example of part of the problem that I was trying to tell Josh about, like a year and a half ago, before he started looking at Shota again or whatever he does. You get this game of telephone where facts are created about people and they become the truth according to the farms. You can't there's no defense. People independently found it today after, I mean, I guess this story has been going on for a couple of years now. And I finally said, like, guys, I can recall one time being in an elevator with a judge. It wasn't that one. And I was in law school and I was certainly not confrontational. It was quite friendly. So I'm not sure where this even fucking came from, but it turned out it was just one dummy on Kiwi Farms who just created the detail. And then he so belligerently insisted that it was the truth, that it became the truth. And there was no one to check it. So this story came out. That's happened in this case in ways that are right here on the face of things and that pop up in observable ways. That's why I like the ability to see some of this stuff. And in this case, Miss Pierce has stated that drugs were out in the open. Those are not the facts alleged in the probable cause statement. They're just simply not the facts. But she's created facts that would create liability, not just for April potentially, but also for Kayla, because the statute is anyone in the room would have this presumptive possession. But the fact created by Miss Pierce isn't true. But she said it in court on the record. The question is, who's gonna prosecute her for it, right? Who's going to go after her for that? Is the state going to go after itself? And the same thing with Alicia Sweep. Alicia Sweep created the concept of a live-in nanny at the Rekieta household, something we've never had. It's never been a thing, actually. And these statements are impactful. They're material to the actual charging of crimes. And they also, of course, conveniently get spread to the public because part of the government machine of prosecution is to have these allegations go out. They exist in the public eye. So now I have people who believe that we had a live-in nanny. Actually, I have people who believe we had 2 live-in nannies who never had a live-in nanny. And that those contain, to put it lightly, those misstatements of fact not only have a legal impact on me, on my wife, on our nanny, they also have a social impact because people make certain determinations and judgments, and people think certain things about that situation. And the ability of the government to utilize these small misrepresentations is quite something, and it's fucking wildly damaging to your, I guess, your social status. I guess that's the word. I don't know how else to say it. I don't like that phrase, but I mean, people have drawn conclusions about that, but that's based entirely on a bastardization of what actually transpired. And it was probably someone's shorthand notes, probably wasn't nefarious, but you think they're mad about it? They're not. Fair warning, they're not mad about it. But this is the way it goes. And this is what I've been trying to kind of hint at for a little bit now. And now there's an opportunity because they've fucking done it. Like it's right there in the open. I can point it out, and it contradicts their own documentation. See, that's kind of the trick with the saying that this substance was out in the open. That contradicts their own documentation about the event. And their drafting of the complaint and then the recitation of facts on the record are two different things, and they mean legally different things. But that's what I'm talking about when I'm saying it's these little things that add up together. Those are the things that really start to, that's how these prosecutions occur. That's how people end up under the thumb of government for significant amounts of times. And someday I can tell you the story, but in our Child Protective Services case is full of those, absolutely full of those. When we found the sources of some of the accusations, and we found out that the accusations were never actually accused, for example. Like they didn't actually make that accusation. Someone took a precautionary statement. So I was looking for this, not that a thing occurred, but they were looking for this thing, and then they just determined that that thing had happened, but it never did. And the way that they conduct their investigations and the way that they communicate with you or don't communicate with you, as it were, it makes it so that you don't even get to figure out the nature of where these claims come from. So you don't get to combat them at all. And some of them are really stupid and don't matter. And other ones are really stupid and really fucking matter. But they will take these half-truths, or they'll take a misread of a statement, and it just changes one word. The addition of live-in to nanny changes the entire scope of the relationship with April or our former nanny, Cheney. Either of them being a live-in nanny is a completely different thing than someone who does not live at our house. Someone who shows up early in the morning and helps get our kids to school is different from someone who sleeps in the house. I don't know how else to describe that, but that was created by someone else. So it's I found this interesting for me. This is probably just my own, catharsis necessary for me, but it's to be able to demonstrate this thing that I've been talking about, where these it's not a big grand conspiracy. There's not like some Barnes. I love Barnes, right? But he talks about like Nick's a champion. He's out there. He's the loudest guy in the county criticizing government. Of course they're going to come after him, right? Like I love that. It's great. It's great. I don't know if Barnes is right on that. I don't dabble in that world, but that's like the grand conspiracy. It's targeted, it's focused, and it really puts me up on some kind of pedestal. And I'm like, I don't see myself that way. I'm just a jackass who fucking goes online and drinks and like tells jokes and stories, and that turned into really pissing a bunch of people off. Sorry. But I don't see myself that way. Like that's the way that Barnes describes it. When I'm talking about like what happens to all sorts of people all the time. This is not unique to me in any capacity, but it's these little twists or misreads or mishears or a note is jotted down wrong. And then that becomes this insular game of telephone, and a story that didn't happen occurs. And then the problem is you have someone who needs to figure out, they have to solve the story. They have to solve the story, and it gets associated with your case, and things get to be just a fucking mess. And it's all because like you added the words live in, for example. In this case, there's a whole bunch of this. Our whole case is full of this shit. And someday there'll, I don't know. I'm gonna get one of those Vegas money hurricane machines. I'm gonna write down all the fucking fucked up facts that they have. Oh, I'm supposed to say that last. Messed up facts that they have on little pieces of paper, and it's gonna blow around. You're just gonna sit in there and grab them. That won't be any fun. Let's see. Allegan News says $20K to keep your side piece out is A-okay. It also says Vince McMahon would pay $20K to keep side piece out. Wildly Lost says there's an elevator in Candy, Ojai County. There is, I think. There's right by the stairs in the courthouse, but I just usually go up the stairs, but some people have trouble going up and down stairs. Keep your mouth shut. Keep your mouth shut. My Spirit to Yours says, I read that a warrant is not issued if the only alleged crime is controlled substance for personal use. So if 2 days before warrant, CPS didn't see any neglect, did kids come back into play to justify a warrant? Okay. I think people missed this when we're reviewing our motion. Now I'm talking about my motion to throw out the warrant. Well, really to get a Frank's hearing to then throw out the warrant. People have this bipolar sort of approach where they say it was about the controlled substances. The search warrant was about the controlled substances. It wasn't about the kids. But then they bring up, well, there's this mandated reporter who's talking about the kids and blah, blah. And when you get down to the final request, just in the warrant affidavit itself, you get down to the final paragraph where it's asking the court to approve the warrant. The first thing they say is investigating potential child neglect and then controlled substances. That matters a lot in regards to that letter, because that letter, here's the way I thought of this just the other day, over the weekend. I thought of how to best describe this letter, the letter from May 20th. So the report comes in on the 16th of May, the potential neglect report. Okay. And then on the 20th of May, Candy, Ojai County Family Services, Health and Human Services sends a letter to the sheriff's department, back to the sheriff's department, that says, in effect, if everything inside this mandated report is true, there is no crime. That's what the letter says effectively. The actual verbiage is, this report does not rise to the level of child neglect under the Minnesota statutes 260D point blah, 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 right? But this is why it becomes critically fucking important that the detective who is in the warrant affidavit utilizing this report, the detective had been told that the mandated report that he's going to investigate does not rise to the level of a criminal act. So he's not asking to investigate a criminal act. By omitting that detail to the judge, he's telling the judge that he's going to investigate a crime that he knows isn't criminal, because he's been told by the body that determines criminality that it's not. And if you don't understand why that is really important, it's that he put that in there because he didn't think he would get the warrant without going after the kids. But he knew that going after the kids was false. He knows it. He knew it when he excluded the letter. He knew it when he included the thing, the report. That report had already been dealt with. So, and again, for people who miss it, the request is for the children first. And why? Because they wouldn't have gotten it. They wouldn't have gotten it. If you ever want to know why a cop lies on a warrant affidavit, it's really simple. He doesn't think he'll get it otherwise. Let's see. Allegan News says Costco and Sam's Club life buying in bulk is not good idea for drugs. Well, go preach it on the mountaintops, brother. Go ahead. Okay, let's see. Speaking of addictive substances, no, that's not what we want to do. I'm going to do this. This is good. That's not a good intro to this. We're going to fuck it. We're doing it live. Here we go. Oh no. The Kids Guide. This is the Kids Guide. Oh my goodness. There's wait, what? Can I? Okay. All right, we're gonna do our best on this. We have a sponsor today, the Kids Guide. It is your free Kids Guide to President Trump. You just visit kidstrumpguide.com, kidstrumpguide.com. It has instructions. It has a task, but it doesn't tell me what the intro statement is. So I'm going to just read the instructions. It says that this statement is designed to capture attention, emphasize President Trump and parents. Wait, I don't even see the guys. I'm going to wing this. I'm going to do them a favor. We'll do it this way. Today's sponsor is the Kids Guide. Guys, it's election season. Your kids are going to be hearing a lot from everywhere, especially if they're around you. You know why? Because you're talking about the election. What your kids need to know, the facts and the issues about these candidates and about their country at this critical time. And we need to make sure that education is coming from proper sources and is not the biased mainstream media and their distorted lies and obfuscation. I mean, I'm sure you saw today Mark Zuckerberg came out and was like, yeah, well, we dabbled a little in election interference, right? Like we just found that out. They've been admitting this for years now, but Mark Zuckerberg came out and confirmed it yet again. What we've got here is a guide to help kids understand what's going on, to help understand President Trump, to help understand the policies that are going to get America back on track. Maybe, I don't know. But this is coming from co-founder Mike Huckabee. Mike Huckabee has been a stalwart advocate for something on the Republican side. And the Kids Guide here is a free guide that goes along with that. So if you want to help educate your kids about this upcoming election and the people involved, check it out. Click on the QR code, whatever you do, whatever the kids do these days. I wish I could read their ad a little bit better, but it doesn't let me scroll down. So we're going to just say it's done. Thekidsguide.com. Get your free guide. Fantastic. Thank you guys so much for sponsoring the show today. Okay. Oh, we've got Buck Master says, are you sick or just coked up to see us? I had delicious Coke today, actually. Am I sick? I don't know. I've been coughing today, so could be sick. Allegan News says, maybe in your free time, you could teach Joe new trick Rumble Studio. Maybe. It's kind of a pain in the ass sometimes, but when it works, it's awesome. I do want to talk to Joe, but it's probably, what's today? Today was Wednesday, right? I don't know. If he's available, I don't know if I'm available tomorrow night or not. You don't care about scheduling. I got to figure out when I'm going to stream next. I got to talk to Joe on the phone the other day. It was really nice, but I wanted to spend a little bit more time chatting with him. I just haven't. I've been busy. I like the maybe in your free time is kind of funny because I don't have a lot. The government really doesn't like. It's crazy. So the government like accuses you of stuff, and then makes you do a bunch of shit. That makes it hard for you to do the parts of life that you need to do. And it's extremely disruptive. And it's really only through really strong familial support and stuff that we've been able to kind of get through. Because the shit that you have to put up with in this. You just like, look, I know I'm going to sound like really libertarian here with this very basic concept, but the idea of innocent until proven guilty is not something that you experience when you're charged with a felony. Like you do not ever feel like you're treated as innocent until a proof of guilt. You don't feel that way. You feel like the government treats you as guilty, period. There's nothing from the very basic step of, if you don't pay them, you stay in jail. That doesn't feel like you're not guilty or innocent until proven guilty. Like, that doesn't feel that way. It feels kind of like they're calling you guilty from the start. And they are. They treat you like it very much. But them's the rubs. But they have you do a whole bunch of stuff as well. And it all costs time and money. And it's great. You really get to see from the inside, like, why people never get out of the system. You know it. You get to read about it. Study about this shit in your political science classes or whatever that you go through, law classes. But when you're actually in this side of the system, like, you realize how fucking oppressive it is. It's crazy. Vicky O'Dwyer says, poor Ricada Law. What did he ever have? What did he ever do to have to go through all this? You know what's funny about that comment, Vicky? Like, I know that's a good joke, but what did I do? Like, I'm not even in the realm of, like, the government hadn't proven shit on me. Like, that's true. But what did I do is a really good question. But don't ask what I did. Like, I'm one of the few people who are positioned to weather this shit. I have, like I said, I had good family support, have some level of resources to deal with this shit. A lot of people don't. Ask what they did, because there's what you're going to find is a lot of people go through a system that turns their life into much bigger disasters than they already were. And that system perpetuates a fucking element of criminality that gets worse. It gets worse and worse and worse. And it's, I'm not talking about, like, the fucking weirdos out in California who are like, oh, well, if they're stabbing people, they probably don't need to go to jail. Like, we don't need bail for no, like, the stabbing people can go to jail. Like, put them in jail. But a whole bunch of people are charged with crimes that you go, well, like, do we really need to, like, ruin their lives over there? Like, they may need to be convicted and all that stuff. I'm not opposed to that, but, like, do we really need to do all this extra to them that will make it almost impossible for them to function in society doing it? Again, I'm not talking about people who are, like, shooting people or raping people. Those are bad people. They made bad choices. And those choices hurt people. That's bad. But you have a lot of people out there who are in a system of just that's just designed to grind you into the fucking dirt. But nice philosophical question. Thank you. What was your name? Vicky? Something? Was it Vicky? Vicky. Prove that it isn't whiskey in that soda cup. Drink it all right now. It's gone. Well, it's not gone. I guess it's just there's leftover Coke in here. I'm gonna have it through a straw. Anyway. Well, guys, I was going to talk some of the Supreme Court stuff, but I don't know that there's much more to do. I wanted to talk about the hearing and give the little nuggets on those lines. I didn't watch other people's coverage. I don't know if they covered it at all, but those lines from the state, that shit matters. And when you're trying to fight it, there's not easy avenues to fight this stuff. People are like, oh, just present your whatever. It's like, it's not like you just walk up with a packet and be like, here. Like, you have to bring it by motion. Then the government tries to, like, tell you how they did lie, but it didn't matter. Anything else. Like, it's a fight, and it all costs money and time and time and time and time and time. And people think that like you could just, oh, well, you just apologize or you just go tell them why they're wrong. It's like, it's not how it works. But in the meanwhile, they create they can trample your rights. They can create these narratives about you and let them run. It's not their fault. Like, what do they know? Medic Mark 22 says, honest question. I can understand how a judge can order someone to not do illegal drugs, but how can they order someone to not drink if the case at hand isn't alcohol related? Because they can. It's just because they can. It's amazing. There's no other answer. It's the court. They can impose these restrictions, and we've just accepted them as acceptable. And really, do you want to be the guy like arguing, well, but like, can I still drink though? I should do exclusively that law. All right. Who gave me the black eye? Who's the abuser? That was me, dude. I fell and hit my face on my bathroom counter. It was great. So, all right, y'all. I think we're going to wrap up the show for the night. I wanted to, like I said, I wanted to bring out those little tidbits. I figured you probably weren't going to get those anywhere else. Everybody else's coverage, again, it's hard for me to watch because I know the story. And so I see them like fumbling around the facts. Not their fault. I'm for once not being an asshole about it. I'm just saying like they weren't there for all of these alleged events. Whereas I was, present for it. And so I see it in the very specific way. I obviously have my own biases, right? But I'm not talking about that. I'm talking about literally living in the factual scenario that these other guys don't have any insight into. So I can't really watch their coverage. So, but I figured no one was going to pick up on the two misrepresentations by Miss Pierce that happened right there in the courtroom. I don't know if anybody else picked up on them. The judge didn't seem to say anything about it. Not that she would. Mr. Gallagher, if he did pick up on them, didn't say anything, which there's not necessarily a reason he should. That's a strategy question. I'm not him, so I have no idea what what his mind is on that stuff. It doesn't really matter. But I wanted to point that out because I thought it was a neat little way to show this insular telephone, how fucking damaging it could be. Because I tell you, my life has been severely impacted by the insular telephone game in so many ways. It's great. But with that, it still trudges on. And so do you, and so do I. But I'm going to go to bed. Hope you guys do too. Hope you have a good night. We'll talk to you soon. I don't know if I'll be streaming again before the weekend. Labor Day weekend is a weekend we spend with our kids every year. We have some great family activity. So I don't know that I'll be streaming. I won't be streaming over the weekend. I don't know if I'll be streaming before the weekend or not, but we'll keep following on locals and you'll get an announcement there when we do have one going. Andrew Starr says, read my last two comments, Nick. Perfect example. Your last two comments. How fucking far back are those? I don't know where they are. Wait. Oh. Andrew Starr. Okay, so something about your kids were taken because you had an infection in your heart and almost died. Had to call an ambulance. Police came along with the ambulance and found some paraphernalia and immediately said I OD'd. Lovely. I don't know where the next one. There we go. Also, the night it happened, my children were staying with family and weren't even there. Yeah, well, the ability to craft a narrative about people that makes them look bad and isn't true and isn't illegal is not exclusive to the police. But man, when they do it, it fucking really damages people's lives. So anyway, enough of that depressing shit. I hope you all have a wonderful night. I'll probably do the Supreme Court stuff next time around. It's just more bickering between the justices and the shape of the Supreme Court going forward. And as we know, anything where women in government is involved, the shape is increasingly round. So we'll see how that happens. I hope you guys have a good night. I do need to get my fucking songs over to Rumble Studio, but another day. All right, guys. Peace. Peace.